Hello and a warm welcome to the program People, Politics and Power. As is our tradition on the program, we shall be drilling deep into another critical issue of national importance as it affects the people and the development of society at large. I am Imoni Amarere. Now, last week, Thursday's landmark judgment by the Supreme Court of Nigeria granting fiscal autonomy to local government councils and cementing their place as the third tier of government in Nigeria has expectedly been generating reactions, debates, and some level of controversy. While the overwhelming view has been that of praise for the judgment, there are those who say it runs against the grain and principles of federalism. Yet some others think a lot more will need to be done to guarantee the re-independence of local governments' administration and make them the primary centers of development for which they were designed. The Supreme Court ruled that it is unconstitutional for state governors to receive and seize funds allocated to local government areas as a practice violates Section 162 of the 1999 Constitution. The court ordered that funds meant for local government councils must be paid directly from the federation account to the local governments rather than through the state governments, and that should be with immediate effect. The court also stressed that local government councils must be governed by democratically elected officials and not by caretaker committees or sole administrators, as has been the case in many states since 1999. In fact, it said the states are under obligation to ensure democratic governance at the third tier of government. Now, the Apex Court also held that no House of Assembly of any state has the power to make laws that could interfere with the monies meant for local government areas. The federal government has since then said that based on that judgment, it will no longer give allocations to unelected local government councils. There are at least 22 states where unelected, hand-picked caretaker committees or sole administrators are holding sway. Now, what is the implication of this development for local government administration? What will be the implication of direct fund allocation for development at the local government area level? Will the Supreme Court judgment bring democracy back to the grassroots? Considering that the Constitution still recognizes the existence of state independent electoral commissions, otherwise known as SECs, which are mere tools in the hands of state governors. Will elected local government officials not willingly submit their allocated funds to state governors who handpicked them for such offices, rather than deploy the funds for development purposes? Will the Supreme Court ruling enhance the practice of federalism, or has it thrown more spanners in the governance crisis in Nigeria? In other words, can local government reforms contribute to resolving the crisis of governance in Nigeria? These and a lot more are issues agitating the minds of many Nigerians. These are issues that we will be trying to tackle on the program today. Stay with us. When we return in a moment, we shall get to meet our panel of discussants, and they are all here in the studio. All right, let's get to meet our panel of discussants. I have from my immediate left Mr. Innocent Lagi, former Attorney General and Commissioner for Justice of Nasarawa State in North Central Nigeria. Thank you so much for joining us.
Thank you for having me.
Also joining us is Mr. Victor Okpatola. Mr. Okpatola is an Abuja-based legal practitioner. Thank you so much for joining us.
Thank you very much.
And very much here with us is Mr. Musa Diko. Mr. Diko is the former chairman of Buhari Area Council in the Federal Capital Territory, Abuja. Thank you so much for joining us.
You're welcome.
So let me begin first by sounding you out on your perception of the Supreme Court judgment. Mr. Lagi.
I think it's a very sound decision. Unfortunately, it appears to create it appears to create an impression as if the Supreme Court tinkered with the Constitution, but that's not the case. In this country, we are used to looking at more of the words of the Constitution rather than the spirit of the Constitution. The spirit of the Constitution wants democracy, and it's very clear in the initial first two sections of the Constitution. So if you are going to interpret the Constitution as the Supreme Court, in my respectful view, did, they applied the golden interpretation of the Constitution. And even if you look at it literally, the judgment of the Supreme Court, hopefully as the conversation goes on, I will explain, was a very sound decision worthy of a Supreme Court. Unfortunately, anyway, I think the Supreme Court chooses and picks the litigants in making determination as to the interpretation of the Constitution. We have a number of clearly uncomfortable decisions during the elections. This particular decision reminisces when Obasanjo withheld funds for Lagos local government, and then it creates similar conversation around then, what happened then and what is happening now, what changed between now and then. But then as we discuss further, you find out that the issues are not the same, though very similar. But as I said, the Supreme Court needs to be a Supreme Court and needs to be a judiciary properly so-called, rather than be right when a particular litigant comes to court and then decide to be wrong if the wrong litigants have come to court. These issues have been going to court a long time. But then, unfortunately, when the federal government wants to do the right thing, the Supreme Court was quick in accepting first the case, delivering judgment within time, and doing the right thing. But these issues had been litigated times without number. They have sent them away, either for lack of local standards. Sometimes they send them, they don't even hear the matters. And that is some culture of the Supreme Court that I think we all need to talk about and all need to discuss. You have the Supreme Court insisting that litigants withdraw an appeal instead of considering it and making a pronouncement one way or the other. So some of the issues that had reached the Supreme Court will never be pronounced about or against because the appeals litigants are compelled to withdraw the appeals rather than get a judgment of the Supreme Court on those issues.
Well, like you said, we will talk a lot more about them later, or maybe a lot has to do with the framing and presentation of such cases.
No, I think it's up to the parties. I think we need to be practical now and be able to look at ourselves. And then, because if the judiciary does not play its own parts in the democratic system, it will be acting the same way we are complaining that the governors are acting. So it's only fair that when we say the governors are not doing their work, the president is not doing its work, we need to also tell the judiciary when they are not doing their work. I mean, it goes round. When one arm of this government is lacking, the other is supposed to check and balance it. If all of them behave the same way, then democracy is at risk.
Mr. Okpatola, your view of that judgment last Thursday.
Okay, first of all, we must understand the perspective the Supreme Court was coming from, given the judgment it gave. It's coming from a public policy molding perspective, power of the Supreme Court. And apparently, when you look at how the case started and how it ended, you understand that the Supreme Court at this time particularly wanted to hear the matter and particularly wanted to rule or decide, give his judgment the way he did. Looking at the fact that, looking at what transpired during the whole hearing process, when the matter was filed, the state attorney generals, they filed their processes. Many of them filed preliminary objections. At a point, other parties wanted to join in the matter. Some state house of assemblies want to join in the matter. Some states, various parties wanted to join in the matter. And the Supreme Court, decided that they should withdraw their motions and it should not be heard as, a lot of things happen. But when you consider everything that happened, you will come to the conclusion that at this particular point in time, the Supreme Court wanted deliberately to put an end, given the fact that they believe, in my own opinion, they believe that local government should be given, should be given a particular stand in which the Constitution envisaged. That is why they interpreted it the way they did. And even beyond the autonomy of local government authority, perusing the process in which the Attorney General of the Federation filed and looking at it the way it was decided upon, you will also realize that the way the Constitution was interpreted, the power of the Attorney General to come in such a manner in which he came, you will understand the fact that the Supreme Court actually wanted to decide the way it did.
All right. Let's go to a politician and a man whom I would describe as a practitioner in the local government sphere. Did this come to you as a surprise?
Of course, it was not a surprise, and it shouldn't be a surprise. Because as a beneficiary, I don't see it as a surprise. I see it as what we have expected, what Nigerians have expected. And of course, as an ordinary person on the street, particularly the local, their belief is give us food on the table. How it comes, where you get it does not matter. And our understanding is that we have 3 tiers of government. And within these 3 tiers of government, every sector has a function. And thank God that lawyers are here. They have told us that there is a provision in the Constitution that defines the local government, that gives function to local government councils, and of course, it is clean and clear that they should be free. And now the Supreme Court, as the father of all means of interpretation of our laws, have decided that the local government should be free. They should have their freedom as enshrined in the Constitution. They should have their powers. They should have, in general terms, the autonomy to be able to operate, to allow distinct administration or governance in our system. Of course, with this freedom now, with this autonomy now, you will bear with me that we are going to benefit much more a lot.
We'll talk about those benefits, but yes. I mean, you were a local government or area council chairman in the FCT. You may not have experienced the kind of seizure or withholding or funds from state governors as your colleagues in the states did. Yes.
Exactly. We have been privileged against the other local government councils in Nigeria. What the state councils have suffered is not what actually 100% we have suffered in the FCT. However, not without. If you remember, sometime we had battle with the FCT administration over who collects tenement rate and other levies. So these were part of the hurdles, these are part of the obstacles within the councils when they are not allowed to operate the way the Constitution has described their operations. So it is a landmark judgment for the local government councils.
And of course, in the FCT, you have always had elections into area councils.
Yes, we have always had elections from time to time.
In some other states,
in the
there are states in Nigeria that have not had local government elections since 1999.
Exactly. That is where I am now joining the FCT and other local governments in Nigeria, because what affects one affects all. That is why I said we are now at a better position with this judgment that the Supreme Court has passed. One thing or the other must have passed through either withdrawing or not withdrawing appeal, either allowing appeal or not allowing appeal. But I want to believe that Supreme Court, in its wisdom, looks at the present situation the country is, particularly economically and security-wise, and decided that, look, we have to allow some things to settle. We have to let go some issues. If we continue to appeal and not allowing it, the economy of this country, the security situation of this country will continue to deteriorate. So I think they must have considered a lot of things. Even discretional factors must have also entered in passing that judgment that I think for now has doused the tension between local government councils and the state governments.
Mr. Lagi, let's look at the execution of this judgment. The federal government has said almost immediately after that judgment that, look, any local government that is not democratically elected will not get allocation for the federation account beginning from the next allocation. That means from our own estimate, well over 440 local governments out of the 774 local governments in Nigeria are not likely to get allocations. How is this likely to impact on local government administration moving forward?
I think it will impact negatively. There's no doubt about it. These resources or this allocation or these revenues are not meant for the bureaucracy at local government or the state. These resources are properly so-called, directed towards services, government service delivery to the communities and the people in the community. It has really nothing to do with whether it is this chairman that gets it or that chairman that gets it or the governor that gets it. Now, I'm just hoping that, and I know the Attorney General of the Federation, and I agree with the President, unfortunately, about some of his policy, but, you cannot make policies without following up to implement them. Section 1 sub 2 of the Constitution is very clear. Anybody who holds power, let me just read quickly so that for the benefit of everybody. Section 1 sub 2 of the Constitution is very clear. The Federal Republic of Nigeria shall not be governed, nor shall any person or group of persons take control of any government of Nigeria or any path thereof, except in accordance with the provisions of this Constitution. Section 7 is very clear that local government systems cannot... Look, local government system administration is guaranteed, the word that was used under the Constitution, guaranteed to be democratical. Now, where anybody at the local government, state and local government, takes over the powers of the local government administration other than as prescribed under Section 7 of the Constitution, of their action offense Section 1 subsection 2 of the Constitution, and Section 1 subsection 2 talks about treason. This is a coup d'etat in Nigeria that is condemned by this Constitution, and it is treasonable. Tinubu wouldn't want anybody to do that to his office. The Senate President will not want anybody to do that to his office. The state governors will not want any of that to be done in the office. So if there is anybody, and it says anybody, any group of person, and any part of Nigeria, if anybody commits this treason, for God's sake, why can't we prosecute them, arrest them immediately and prosecute them for the offenses they commit? Because it's an offense against the Constitution. This is not a prohibition by a penal law. It is a prohibition by the Constitution. This is the second provision of the Constitution. It is that serious. If soldiers take over power in Nigeria and they fail, they will be sentenced and be shot to death. Why then will we allow miscreant, stupid people who have no sense take over not only the governance of this country, but take over the resources of this country, do not account to them, and take them away?
And in other ways, Mr. Lagi, you're saying that over the years, this is 25 years into democracy in Nigeria.
And it is...
we have allowed treasonable offenses to prevail.
We have institutionalized it. Why do we need this decision of the Supreme Court? The section of the Supreme Court that was interpreted now was not in any of the amendment. It existed from 1999 to date. So it was only now that the Supreme Court is now exercising its jurisdiction to say, and this is what this judgment is about, state governments cannot continue to misappropriate local government funds, because that is what is going on. The Constitution in section 162 makes provision for how these funds will be divided. The formula is set out there. In fact, sections 120 is also very clear. You are supposed to have a joint state and local government account. That provision says all the total revenue in the joint local government account shall be distributed amongst the local government. Let me make this point before I even go further. There is not an inch of land in any part of this country that is called a state. A state is a conglomeration of local governments. So state exists only as a bureaucracy for the purposes of governing local governments. Local governments have functions. So states are supposed to actually constitutionally have two accounts, only two accounts. One is the joint state and local government account. The other one is the consolidated account. The joint account is not meant for the control of state and execution of projects for the local governments. That's not the intent of the Constitution. Those monies are supposed to ordinarily be kept in those accounts for the purpose of allocation to local governments. All the monies. The exception is the provision for the consolidated account that is contained under section 120 of the Constitution, which says there shall also be, other than the joint account, there shall also be a consolidated account. As we go now, read exact provisions of that section. Then from the consolidated account, that is when you then make appropriation for expenditure. State governments, the bureaucracy of state, the judiciary, the executive, the legislature exist only for governance purposes, not for project execution purposes as we now have. So a governor building a road between one local government and another is all right, but then the government of a state, as envisaged by the 1999 Constitution, other than the local government that have functions. The interpretation and the word used by the Constitution are also quite exciting. Local governments have functions. States have powers. So the power of a governor is to be an executive officer of the state. So he is a supervisor and a trustee for the local government system, because there is no inch of land and we can't spend resources of the person and the governor. So every resource or revenue that goes to a state goes for the purposes of an intent of development for the local government and services for the local government. None is supposed to go except the recurrent what comes to the government for the administration of the State House of Assembly, for the administration of the government office, and for the administration of governance for and on behalf of the local government. Because the state does not govern a state. The state governs the local government that makes up the state. Now, so this is the aberration. So if monies are appropriated for local governments and the state government, which is the bureaucracy now, use up the money, take 30% of it as security vote only for the governor to spend on his own, and then choose and decide what projects you are going to do for a local government. Some local governments have only a stretch of road in the past 20 years. When if you had given the allocation to them, each local government can then carry out the functions the Constitution says. You can build parks, you can build markets, you can administer sanitation, all of those issues. Same that the chairman was talking about, tenement rate, refuse disposal. For example, in Abuja, how can states do that? Why will states build markets? Why will states build abattoirs? Why will states build motor parks? Why will even the president allocate buses for commuting of people to a state government? When if we want to move persons from one place to another, the people that need it are people at the local government. Why do you allocate agricultural equipment to a state government who will then give it to their friends and cronies instead of sending them to the local government where the people that farm are actually situated? Why do you deliver fertilizers to a state government when you can just take it directly to the people you govern? So the issue now is we have finally been able to, I hope, define the kind of federation we have in Nigeria. We have three federating units, whether we like it or not. We have the federal government, the state government, and the local government.
The Constitution says so, and
Absolutely.
the Supreme Court has affirmed that.
Outside that, now when you look at the powers of the federal government, and it is quite unique, foreign affairs, the army, certain things that that can only be managed for and on behalf of the 37 states, including the FCT. That is the core function of the federal government, not to also interfere in the core issues of how local governments are managed. Because the management of local governments then goes to the second tier of government, which is the state. Then that is for the purposes of managing the local government, not necessarily running the local governments. Then you go to the local government that now manages the community and the services that needs to be delivered to the people. So I hope that we're growing. I hope that we will take this seriously. But we can't keep undermining the constitutions as we do. Anybody who commits treason in Nigeria, either it is at the local government level, at the ward level, at the state level, or at the federal level, must be treated the same with any military coup in this country. And we can't play lip service to the constitution. We can't. We can't.
Okay, let's bring you in now, Mr. Patola. Do you think that this judgment is likely to restore democracy at the local government level?
Actually, this judgment is a step closer to true federalism, to the practice of true federalism in Nigeria. The judgment itself...
There are those who have criticized the judgment and saying that it, in fact, goes against the grain and principle of federalism.
We'll get there. I'll discuss on that. But looking at the judgment, the CTC of the judgment is not out, but we can take a glimpse of what the judgment would be, you know, looking at the prayers the Attorney General of the Federation prayed in the process he filed. When you look at the process filed by the Attorney General of the Federation, one of those, the way he couched it is a little bit different from what it is that we've always seen about those who have approached the Supreme Court. In the process he filed, one of the prayers was that any public official, any governor, any public official generally, who in any way derogate from the judgment of the Supreme Court, maybe governor, maybe state House of Assembly, that derogate from the judgment of the Supreme Court by passing a law or making any administrative process to ensure that there is no democratically elected governor, democratically elected local government official that in any way derogate from the judgment, that it amounts to gross misconduct and that the Attorney General of the Federation can prosecute such person after office. So if it's a governor, as it stands now, going back to what the Supreme Court decided, if any governor in any way derogate from this judgment and does not allow democratically elected local government official to take charge of local government in Nigeria, it's a gross misconduct. That means it's a ground upon which the State House of Assembly can remove such governor, going by the provisions of the Constitution. So the way in which he has couched it has made it different first, and make it self-reinforcing and executory in another sense. So that means any governor, even if it's the State House of Assembly that passes any law to derogate from this judgment, because they don't have immunity, the Attorney General of the Federation can prosecute them in itself using any of the laws we have generally. And going by the nature of this judgment, it's actually a very good thing. Those who are advocating against this judgment, that they felt that it does not follow the true provisions of the Constitution, I hope they read the judgment when it comes out, and they read the way and manner in which the Supreme Court arrived at its conclusion. The major ground upon which the Supreme Court arrived at its conclusion is the fact that what does the Constitution want? What is the aim of the Constitution? We agree there are contradictory positions in the Constitution in a way, particularly relating to local government, was not elegantly drafted, giving a power in one instance and collecting the power in another instance. So in order to solve this quagmire, the Supreme Court went back to the original intent of the Constitution, the original intent of the drafters of this Constitution, which is true federalism, which is that there should be a federal government, there should be a state government, and that there should be a local government. That is the ground, that is the foundation upon which this judgment is premised to begin with. Now going to the issue of execution. First, before we even go into the issue of execution, this judgment is a good development. First of all, it takes away the synergy of attention a little bit from the federal government and from the state government and focusing it on the local government. Now, democracy, as beautiful as it is, does not exculpate the citizens. Democracy, as beautiful as it is, places a heavy burden on the citizen, and this burden, the burden of vigilance. Now that this decision is out, the burden is on the people now to ensure that the local government chairman are accountable for whatever money that they're being given, from henceforth. When you look at this judgment, it says immediate. What was the word? What was the name? It's but what it's actually saying
yes,
is
its
that it should be
implementation
immediate
is
implementation.
immediate. Yes.
That immediate. So once the judgment is given, it should be implemented immediately. That is the second to the last prayer the Attorney General Federation prayed, that it should be immediate. Now, the people, we have a burden to ensure their accountability. This money that will be going to the local government are not small money. They are huge amount of money. It is the burden of the people. First of all, you cannot enforce what you do not understand. A lot of people do not understand the system and process of local government in Nigeria. As I'm talking to you right now, a lot of people do not understand that what is obtainable in the federal is also obtainable in the local government. For instance, now, there is the president, there's the National Assembly. The National Assembly has the power of check and balance on the executive. Same thing happens at the local government level. There is a council, local government council, which comprises of all the councillors.
There's actually a legislative council
so
at local government level, right?
Those are the national, permit me to use, that is the National Assembly of Local Government. Their burden, their role, one of their role, and all the states have a local government development law. Lagos State has, all the state has a local government development that highlights the role of this local government council, as the case may be. Their burden, their role actually is to ensure a check system on the local government chairman, which is the executive at the local government level. So now the people should understand that it is no longer business as usual, where you will elect just anybody because you feel the position of a councillor is so lowly. Because the people that will checkmate or check and balance the local government chairman are the councillors. As a matter of fact, the councillor can remove the local government chairman when there's issue of gross misconduct. The councillors has the power to do that, coming together to remove the local government chairman. So what I'm saying in essence is that it is high time people go back and focus on local government. And even, you see, this is not even about the people alone. Political parties too. Political parties need to focus now on local government chairman. Not only on local government chairman seat, even the councillor seat. So instead of putting synergy of attention, resources on the governor's seat, on the president's seat, on senator, if you can wrestle the power in the state, even if you do not win the local government chairman seat, even if your party do not win the local government chairman seat, the fact that your party wins the majority of councillorship seat in itself will put the chairman on its toes and allow one of the major functions of political party, which is to put the other party on its toes. Yeah. So basically,
viable opposition at that level.
Viable opposition at that level. So in the long run, at this point, at this time, we should not wait. You know, one of the arguments against this judgment is that it is not enough, that the Supreme Court should even go further and allow INEC to conduct election for local government, which is state level. But that was not part of the prayers. And for instance, as these particular cases, the Supreme Court has bent over backward, hard, to deliver this judgment, to ensure that local government,
the Supreme Court could not have granted prayers that were not sought.
To begin with. So basically, what I am now saying is that the Supreme Court has done what it is that it can do, unless somebody else is, approach the Supreme Court on the issue of
State independent electoral commissions.
The people have a burden at this particular time to ensure accountability. There should be NGOs per time in this country advocating now, as it is now, and making strong advocacy to put synergy of attention on local government chairman, local government council seat, local government councillor seat right now. The people must understand how the council seat, for instance now, many people do not even understand. Okay, let's put FCT as an instance now. Many people do not understand the lawmaking process in the local government. They don't understand how these bylaws are passed. Even if there is a bylaw passed today, as I'm talking to you, that will affect a lot of people in FCT, we don't know. So the attention should return.
We need to be a little bit careful because while we have legislative powers at the state level, and we have two legislative lists tentatively under the Constitution, the one that can be exercised by the National Assembly and the concurrent legislative list that can be
Acted upon,
by the state
level, yes.
and the federal level. At the local government level, what we have are functions, not powers. So, as I said earlier, the main purpose of a state is to provide governance. And you provide governance when you provide rules. You provide laws that guide people on how to do, then you punish people when they go outside the law, because the law defines conduct. But at the local level, bylaws are not generally applicable to every local government. They are mostly instruction and administrative direction on how the functions of local governments can be carried out. They are not necessarily enforceable in the way the act of a National Assembly or a law by a House of Assembly will have the same effect. For example, you can provide sanctions at the local government for non-compliance with taxes. You can always find that to apply. I mean, a state can make those laws that are applicable, generally applicable to local governments. But you cannot, for example, local government cannot make penal laws in the sense that they will.
When I mentioned the National Assembly, made reference to it to local government council, is to make people who are listening to us understand the legislative powers that the local government council has. It's just a way to make them understand better that those people, they have lawmaking powers. These people, looking at the role and the power and the role given to them by the Constitution, to whatever the roles given to them under the Constitution and the residual list. Okay. They have the powers to make these laws under the residual. So my allusion to the National Assembly is not that this local government council also have the same powers.
Okay, that's clearly understood. Let's bring in Mr. Diko now. From what has been said, it's just very clear that the local governments are supposed to be the centers of development. And they require the resources that are so allocated to them from the Federation account to carry out such developmental projects. But of course, what we have seen over the years, at least in the last 25 years of our democratic journey, is an abortion of that process in most states of the Federation. Now, with this judgment, what do you think that such direct fund allocation will do to these local governments? Will there be, are we likely to see a lot more development at local government level? Are we likely to see greater level of accountability? Are we likely to see an increased level of transparency from the local governments?
Yeah, the judgment is so clear. The judgment is very clear to the understanding of an ordinary man. And of course, people have argued in some quarters, just like my brother here have said, that the judgment was not passed in the direction where it should have been. But the fact remains that from the former AG here, he has clearly told us here what the Constitution is saying. And that is exactly what I think the Supreme Court had actually followed. I had a discussion with someone this morning, and I said, if we follow strictly what the Constitution is, our president will be a ceremonial president. And that is just what he has said here. If you look at the functions of a local government chairman or of a local government council, it takes every authorities, every stress out of a governor. The governor will just sit as a supervisory councillor, those in an area council. He will sit down to watch what the local governments are doing, because looking at the construction of roads, which borders one local government to one local government. Before you move from one local government to a state, you are passing through a local government before you say a state government. And within that state government, you are passing through a local government. So by this judgment, it is so clear for us that we are trying to go back to the origin of what we have always been or what we wanted, looking at where the Constitution started in the 1976, what it described local government, how it created local government, the intention of creating local government. It's a government that has to do with grassroots. It's a government that has to do with the people. In fact, I told someone in one of the interviews that, look, local government is supposed to be the first tier of government, not even the third tier of government. Because whatever you do it within the local government. Whatever you do it within the ward. And that is why we have councillors at the ward level who oversees at least the traditional affairs, the administrative affairs of that ward, and in turn move it to the center of the local government. So I want to say here that what the Supreme Court has done it in good faith and to allow for practice of real federalism that we have chosen. And I want to say here that going through what the judgment has also said about the autonomy, look, we don't need to start going back to the court and start asking that the state, local government be allowed to face the INEC when it comes to election. The state should also go into the same constitution and see what it has provided for the state's assemblies. Make laws for these people. Make laws to enable proper supervision of these people. That is the councils. And of course, even when it comes to disbursement of funds to local councils, there is still a provision in the same constitution that has allowed that the state assembly will make laws for the state government to provide more funds to local government. There is still a provision in this same constitution that has allowed that the state will make laws to allow a situation where local government partake in decision-taking of the general cycle of the state. So where the state's governor operates, he should carry the local government along in decision-takings, in decision-makings, so that the people at the grassroots will feel the impact of the governor. But like the AG has said, we are so comfortable now that the local government are going to operate in the way and manner the Constitution has created them, the functions that the Constitution has given, the powers that are within the states to now be exercised on the local government. So these things are distinct in nature. And I want to say the local government now know that he has more challenge than ever. Because the watch that has been on a state governor is now going to shift down on the local government chairman. Because the functions of the local government chairman are so enormous in the Constitution that virtually when it comes to providing infrastructure, to providing governance, it is the local government chairman.
We need to go and dust up all those provisions in the Constitution and study them
You need to agree with me that when the local government chairman wants to hold a council security meeting, he involved the traditional rulers from the grassroots, the Dekachis, the Miangwas, the Hakimis. But when the governor wants to hold a security meeting, he picked only one, probably a class chief from maybe 24 local government or 30 local government. One class chief comes to represent this 30 local government or thereabout. And this class chief that come with the information that has come from the local government, from the ward, to now give to the governor. Whereas when a local council chairman is holding this kind of meeting, he gets his information firsthand from the councillor to the hamlet chief, to the village head, to the hakimi, to the dekachi, name them. So this definition or this judgment has brought out the real definition of local government and the state government. And as such, I think the Constitution will also help, like they have said, approaching the court again to see how INEC can begin to conduct the local government elections. But I think within the Constitution, there is a provision where the state can make available what will be suitable for these elections. I will not forget, in one of our findings, why the state governor decided to take over local government affairs was because some of the local government chairmen were actually not applying Constitution in dealing with the affairs of the local government. Some were mismanaging resources. Some were becoming so powerful to the extent that you don't even talk to a local government chairman. And at that position, because the supervisor is there, he decided that, look, you have to step down. I have to tell you what to do. That is one of the things that brought about these caretaker committees, the removal of chairman. Otherwise, the governors know that the Constitution has defined that there should be freedom for local government areas.
Mr. Lagi, very quickly, given the limited amount of time we have, I'd like you to address this very quickly. The dilemma that this judgment seemed to have brought about, that is the continued existence of state independent electoral commissions, knowing that these electoral commissions at the state level are in the within the control of state governors. They appoint the members. They practically carry out what the government or the governor wants. So
now, I think the problem with local government election is a judiciary problem, not necessarily the electoral bodies at the state. I mean, at the last local government election in Nasarawa State, our cases came up to the Supreme Court. And I'm saying this because I had settled the brief. The Court of Appeal said they didn't have jurisdiction. The Supreme Court said, look, we have already decided on that. Withdraw your appeal. But this is the practical truth about the situation. Section 1, subsection 2 says you can't hold power except as the Constitution stated. You cannot contest any elections in Nigeria except through political parties. Now, you cannot discriminate on access to justice between a dispute between indigents, the same losses, same rights as guaranteed under the Constitution, who can pass a state high court and who can go up to the Supreme Court. I understand that we can do that. But you know, when it comes to issues, fundamental issues, and those are the things that we need to make clear. We had that dilemma on the plateau in the last election in respect of the plateau. The Supreme Court gave a different judgment, the Courts of Appeal gave a different judgment, so you have two different kinds of justice. You have a justice if you go to the bigger court, you get injustice if you don't go as high as the bigger court. And so when the state, unfortunately so, when the states are controlled the way they are controlled, they are detached completely from the federal system of supervision amongst the tiers of government. So we have tiers of government, then we have arms of government. Outside that, we have levels of these arms of government. So if you have a judiciary in the state that has a final say in a matter that involves nomination by a political party at the national level. So, for example, if you have a pre-election dispute in respect of primaries conducted in a local government election, you can't go to the Court of Appeal because the Court of Appeal will say we don't have jurisdiction because the Electoral Act or the Constitution have ousted our jurisdiction, same as they gave this interpretation. But if you want to apply that literally, disputes between political parties are not local disputes because these political parties are not registered at the state level by the State National Electoral Commission. So it is any dispute in respect of primary elections or nomination of parties will be governed by nomination of parties, and it can go as high as the Supreme Court.
Now, what I meant when I asked that question is the charade that we have seen over the years in relation to conduct of local government elections at state levels, where, for instance, in state A, party B that is in power wins all the elections, all the positions.
My point exactly. Until the Supreme Court, since 1999 to date, gave a pronouncement on this, there is a hope that something can be done, that every citizen of Nigeria is a Nigerian and is entitled to the same laws, to the same rights as the governor. Now, if you treat states as if they are not part of the federation by discriminating on terms of provision of jurisdiction for resolution of common disputes, you are continually going to have a state within a state.
Okay.
And that is what I think we need to do. But let me see if I can round this up with this.
Very quickly, because we have...
This is quickly.
Yes.
So the controversy over the Supreme Court decision is in respect of Section 162. 162.3 will be the key section. I will come back to it when I read the other two sections. 162 subsection 3 said, any amount standing in the credit of the Federation account shall be distributed amongst the federal government 1, state government 2, and local government 3. If you go down, the point of argument comes to when we discuss subsection 6 of 162. Each state shall maintain a special account to be called the joint state and local government account, from which, understandably so, from which money standing in the credit of local government will be paid into it. Now, the main spirit of this constitution will always go back to subsection 3, which says this money, no matter where they are kept, they are supposed to go to the state federal government, and the local government. So any other provision does not derogate from the intent of subsection 3. Now, when you come down to subsection 7 of the same section, it says each state shall pay to the local government council in the area of jurisdiction such proportion. And the key word under subsection 3 is the total revenue on such term and in such manner as may be prescribed by the National Assembly. Total revenue, a portion of the total revenue, not a portion of that revenue. The portion of the total revenue is supposed to be paid to the local government, not a part of it, not a quantum of it as the state governors are doing. So if the total of the total revenue are supposed to be distributed to the local government, they should be. But if you confront a judicial body with powers like the one Supreme Court has under Section 6 of Section 6 of the Constitution and ask them to interpret whether or not state governors can tamper with the funds meant by subsection 3 of the Constitution by applying subsection 7 of the Constitution, the responsibility and the duty of the court is to give the original meaning and the intent of the Constitution on revenues to these three acts of government. And if you are doing that, you have to go back to section 162, subsection 3, and you can then make an order to give effect to the main intent of the for the main intent to the beneficiaries of these revenues. And you have to then be able to make the order the Supreme Court made. And I think the Supreme Court is classic on that. There's no aberration about it. They did not fault any provisions of the Constitution.
Thank you so much, Mr. Lagi. Mr. Patula, very quickly, 30 seconds to round off your thoughts.
Okay.
Very quickly.
At this point, it's given. The Supreme Court has given its decision and it's binding. At this point, what we should be looking at is focus on local government chairmen and area councils, then accountability, which is very important at this point. So,
Mr. Diko?
I did say so that local government now should be prepared to face Nigerians at their various local government areas for accountability, for how transparent they operate, and of course for how effective they will deliver governance at the local government.
Thank you so much. There are a lot more issues that we need to deal with that we don't have time to deal with here, for instance. But we will come back at some other time to look at these issues. But at this point...
My last word is I hope the president has the balls to pursue infringers of Section 1, subsection 2. I mean, he had made very, very serious policy decisions.
And he should have the courage to
his intent can only be defined by how he pursues this other infringement of the Constitution to the latter. Okay. You cannot be handicapped by saying we don't have a provision to deal with why we shouldn't have democratically elected local government.
The Constitution has provided all of that.
He just needs to act. He has
all
the
right.
policy.
Thank you so much.
Itself,
thank you.
Can be enforced, actually. Part of the prayers in the judgment is that the Attorney General of the Federation can prosecute anybody. It's part of the prayers.
Unfortunately,
let's hope that the Attorney General will
content of the court and all
will have the presence of mind to prosecute anyone who defaults this judgment.
Absolutely.
Thank you so much, gentlemen. Mr. Innocent Lagi, former Attorney General and Commissioner for Justice, Nasarawa State. Thank you so much. Mr. Victor Patola is an Abuja-based legal practitioner. Thank you so much for your time. And Mr. Musa Diko, former chairman, Buhari Area Council of the Federal Capital Territory, Abuja. Thank you for your time.
My pleasure always.
All right, and for your viewers out there, we want to thank you for investing your time with us. Join us again when we bring you a fresh edition of the program, People, Politics, and Power. Bye for now.